Hello, everybody. Welcome to our Data Practices Potpourri webinar. Thank you for joining us. If you've joined us for a webinar previously, you know that the Data Practices Office is a statewide resource on data practices and the open meeting law. Most of what we do is answer questions related to those laws from members of the public and government. So please feel free to reach out to us if you'd like to discuss a data request, a classification, or whether a meeting can be closed. Webinars are recorded, so if you missed part of today's webinar or want to go back and watch one of our prior series, they are posted on the Data Practices Office YouTube page. So I'm going to show you how to find those videos on our website, which is the link on this slide. So you can always find our YouTube page by going to the footer of our website and clicking that YouTube icon, or you can go to our News and Events tab, go to Events, and then click Webinars here. Once you're on our webinars page, there are some FAQs for audios if you're having any audio issues at any of our webinars, and you can also find a link to our YouTube channel right here. So the recording from today is going to be posted on our website within a couple days, and you'll be able to view it if you want to go back and watch anything. So I'm going to transfer the file for our PowerPoint right now in case you'd like to download it. So you should find a pop-up box on your screen. If you'd like to save a copy of our PowerPoint, you can go ahead and do that. We also post copies of the PowerPoint on our webinar page on our website as well. I'll post the PowerPoint again later in the webinar for those of you who missed it this time around. So today's webinar is a new style that we're calling Data Practices Potpourri. We receive a pretty wide range of questions every month, and many of our partners and past webinar attendees have common questions that we think others would be interested in discussing. So these potpourri style webinars will be an opportunity to hear what issues other government folks and members of the public are dealing with. As usual, we'll leave some time for a Q&A session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. When sending in the questions, please send them to all panelists so we can be sure to see them. All right, so we're just going to get started. Question number 1. Are there exceptions to an entity's obligation to respond to data requests for unduly burdensome requests? No. So the Data Practices Act does not currently have any exceptions for unduly burdensome requests. Many entities are receiving requests for larger amounts of data, especially now that we're working in an electronic world. If the request is from a member of the public, the response time is still within a reasonable amount of time. And what is considered reasonable will change depending on a number of factors, including the size of the request and the amount of responsive data there is. So this provides some flexibility in responding to these larger requests, which could take a substantial amount of time. There is the Webster versus Hennepin County case that went up to the Minnesota Supreme Court, and it contained some unduly burdensome arguments. However, the Supreme Court stated that they didn't have appellate jurisdiction to address those arguments, so we didn't get any case law on this issue. There are, however, some strategies that government can choose to implement when responding to these large requests, such as providing data on a rolling basis as it becomes available. An example of this would be prioritizing certain time frames if the request covers a large period of time. Question number 2. How should government entities respond to requests by attorneys for data about their clients? So the answer to this one is it depends. If the responsive data are public, the entity should provide the attorney the data. But if the data are private data on the client, it depends on the situation. But a conservative approach would be to require the attorney to get written informed consent from their client to receive access to that private data. Question number 3. Can entities charge for reviewing responsive data? So probably not. It's unclear what reviewing means in the context of responding to a data request. Generally, if it's a public request for electronic data or paper copies of 100 pages or more, an entity can charge for the actual cost of providing copies. This includes time to search and retrieve the data, so finding the responsive data, time to make and transmit the copies, so going to the copier, making the copies, or exporting files onto a USB or CD, as well as the cost of materials, so the cost of that USB or CD. Once an entity has retrieved that responsive data, the Data Practices Act doesn't permit an entity to charge for then going back and reviewing that responsive data, and the entity can't charge for redaction or the cost of separating public data from not public data. If you have copy cost questions, we have a whole page on our website that goes through copy costs and what's included in actual costs, both for members of the public and data subjects, because it differs. Question number 4. Does informed consent have to be in writing, or can you verify consent over the phone? So Minnesota Rules 1205.1400, subpart 4, requires that all informed consent be in writing. Although a verbal confirmation may be faster or more efficient, written informed consent is required by the rules. Another benefit to written informed consent is that you have proper documentation down the road if the scope of the consent or what was authorized to be released is challenged. If you have questions about informed consent, we also have example informed consents on our website as well. Question number 5. Can public bodies use electronic polling or other features during virtual public meetings to take a vote? Sorry about that typo on that slide. No. So if the public body is holding a meeting under 13D.02 or 13D.021, both of these sections of the open meeting law require that votes be taken by roll call. There's not currently an exception to the roll call requirement, even if the vote's unanimous. So the polling option in virtual meetings would not satisfy this roll call requirement. There may also be issues with using polling technology during meetings because these interactive features might not satisfy the requirement that all members can hear all discussion and testimony. Further, under both 13D.02 and 13D.021, when there are members of the public in the regular meeting room, if members of the public are there, there's a requirement that they must also see and hear all votes in addition to discussion and testimony. So again, that virtual polling wouldn't be appropriate because it wouldn't meet those requirements. Question number 6. Are there alternative forms of identification or ways of verifying identity in a remote environment? So probably, yes. It's up to each entity to determine how much information is necessary to accurately verify someone's identity in order to effectively protect not public data, and determine whether multiple or alternate methods or options for verification are appropriate. The methods of verifying the identity for a data subject are typically listed in an entity's data subject access policies. So that would be a good place to start to see if there are other methods available that an entity has already approved. Considering where many of us are working virtually right now, entities may want to get creative in how they use technology, such as verifying identity through a video call where the individual can show their identification card in some way. Okay, question number 7. Do public bodies have to record their public virtual meetings? No. The open meeting law does not require that open meetings be recorded. It only requires that public bodies record closed meetings, except for those that are closed pursuant to attorney-client privilege. But recording meetings and making them available to the public might be helpful while we're navigating this virtual environment. However, if entities choose to record their public meetings, there are a few things that they might want to consider. Public bodies should think about what they include in a record or recording of a public meeting, because pursuant to Minnesota Statute 13D.05, Subdivision 1C, a record of the meeting, regardless of form, shall be public. That's what that section says. So note that this doesn't extend to underlying data that are discussed at open meetings. Those data retain their original classification. But because these recordings or the record of meetings are public, public bodies should consider whether the recording is necessary for a complete record of the meeting. Some entities run into issues if they allow public comment periods because the public body doesn't have control over what the public says. If the public body records the public comment portions of a public meeting, the recording is likely considered public as it's still a record of a meeting. All right, so we have some time for questions. Those were some of the top questions that we received this month. If you have any other questions about the questions that we just reviewed or any other data practice topics, you can feel free to send them to all panelists in the Q&A panel. While you're thinking about your questions, we want to mention another office at the Department of Administration, the State Demographics Center, which is leading the work on the 2020 census this year. We're highlighting the work because a good census is the foundation for a fair democracy, and we know that you all want to be counted, and the folks that you work with and serve want to be counted as well. These are likely the last 2 days to be counted, so we want to make sure that we provide this information to everybody who needs it. You can learn more at the website that's listed on the slide. This is going to allow Minnesotans to keep our representation in Congress and get the funding for needed services. I think we only have a couple days left, so spread the word if you can to ensure we get an accurate and complete count in Minnesota. I'm going to put a copy of the PowerPoint up again for those of you who missed it the first time around while we're taking questions. It will also be available on our website. If you hear any pauses or some silence while we're doing this Q&A session, don't worry, your audio is fine. It's just because we're making sure we get to all the questions that are submitted. So please keep sending those in.
Okay, we have a lot of questions, which is great, and we will try to get to as many of them as we can. I'm going to kind of take some of the easier ones off the top here. So someone asked, what rules were we referring to in the Q&A or the question part? It's the Minnesota Administrative Rules implementing Chapter 13. So Minnesota Rules, Chapter 1205, implements are the administrative rules implementing Chapter 13. So that's an additional source of law that's related to data practices and specifically the implementation of the statutes on data on individuals. So there is a section that discusses informed consent and says that it needs to be in writing. I'm just scrolling. There's a question about personnel data. And the question is, let's say a non-represented employee is disciplined and grieves it up through the appeal process stated in the personnel policy. The final option is to appeal it to the employer-appointed Personnel Board of Appeals, a 3-person panel made up of non-employees. And the question is the appeal to the Personnel Board of Appeals an example of a later proceeding? So that refers to Section 13.43, Subdivision 2, which sets out the public personnel data, which says that the final disposition of any disciplinary action is public. And then in Subdivision 2B, it says that the final decision about disciplinary action, regardless of any later proceedings, is public. So if it's a final decision by the employer and this person is not subject to a collective bargaining agreement, then that is the final disposition, which would be public. So if it's the final decision of the employer, again, and if this employee is not represented by a union, then that is the final disposition, and that would be public. There was a follow-up question on that related to a veteran's preference hearing and whether that is a later proceeding. And I'm going to refer you to Advisory Opinion 00-035, which discusses the Annandale case from 1989, which was a Supreme Court case that talked about veterans' preference hearings, and then 1343 was later amended with that language about later proceedings. So the final decision of the employer is the final disposition, regardless of whether there is a veterans' preference hearing for that employee.
We have another personnel data related question about are open and closed the only 2 statuses we should use for describing a complaint against an employee. We went into a lot more detail on this question in our personnel series. I think it was the 3rd webinar in that series. It's on our YouTube page if you want to get more details on that. But as far as existence and status of a complaint or charge, the answer to that is either it exists or it doesn't exist. If somebody wants more information and the status is closed, it's private personnel data, and there was a complaint that existed and there was no discipline, so they don't get access. The Navarre case versus South Washington County Schools goes into a lot more detail about what government entities are able to say when there is a complaint that exists against a government employee. And that would be helpful to review if you have questions about that.
There is a question, is there a definition of a public official for 13.43 Subdivision 2E? So in that provision, Subdivision 2E, it lists out the individuals that are both state-level public officials and then local public officials. Those 2 groups of public officials are treated differently for 1343, so I would refer back to 2E that lists out the positions and the individuals who are public officials. There's a question about copy costs, and it says, when a requester asks for data normally available for an approved fee, such as a vital record, like abstracts or title documents, can the entity charge their usual fee for the data, or is data practices a workaround? So it's another question where it depends. If there's a statutory fee, like there is, for instance, for birth certificates or at the Department of Public Safety, there is a statutory charge for state accident reports. That charge does not apply to local law enforcement, so local law enforcement would be subject to the Data Practices Act and the usual copy cost structure. So it will depend on if there is a statutory cost, and in that case, you would go ahead and charge that copy cost. Otherwise, the Data Practices Act will define which charges how you can charge for copies.
So another question, just asking about when our travel trainings will be back up and running. We right now aren't doing any in-person trainings, so we're going to be doing these free monthly lunchtime webinars for the foreseeable future, and then we're also going to be doing remote workshops. So it'll replace our in-person workshops that we were previously holding. We're doing a half-day intro. We're going to be doing a full-day law enforcement this fall, and we'll probably be working in another full-day personnel as well. So keep an eye out for those. We will be doing our workshops. They'll just be in a remote environment, but we are limiting the attendance to 25 attendees still, so we can still do those small group exercises.
If the data request is made to a specific department at our county, but other departments have data related to this request, is the county's responsibility to gather all data located in the county? So for counties in particular, it's a little more challenging because every elected official is their own responsible authority, in addition to the general administrator of county administration, in addition to the Veterans Service Officer, and there's an additional responsible authority. So there are multiple responsible authorities. So look to your policies and then look to the request. If the request says, I'm looking for data in the whole county related to this, then the responsibility would be, if it came into the county sheriff, but it's for all county documents, maybe the sheriff's DPCO can let the other county departments or programs know that this person is looking for all data, or you can direct the requester to the other responsible authorities and the other departments so that they can gather the responsive data. So it will kind of depend on how the request came in and then what the request says.
Another question, do you have recommendations on what an entity must or can do to allow inspection during these times? This is a difficult question. There is still an obligation to facilitate inspection, as there's not an exception in the Data Practices Act for that right now, but this will probably depend on what you're able to do with the technology that you have, and maybe talking with your IT folks to see if there's any ways that they can facilitate some remote inspection options through share sites, or whether you can do in-person inspection will probably depend on what your local entity's requirements are and limitations are, and if they're even open to the public. But if you want to talk about this further, you can feel free to give us a call and we can talk about some of the options that we've heard people discuss.
Here's another one about copy costs. It says, can we hit on charging for reviewing data? We have a guy who knows we cannot charge, so he continues to ask for large data requests. It will take us a whole day to compile the data. We cannot charge for compiling time. That's the question part. We cannot charge for compiling time, question mark. Or can we charge for transcription time? What you are allowed to charge for a public data requester is search and retrieval time when they're asking for copies. If they're only asking for inspection, regardless of how long it takes you to search and retrieve or to redact, that's always going to be free. And there are a couple advisory opinions that say that that person who's inspecting can also come in and take pictures of the data or use their own equipment. There's a very old one where a requester brought in his own scanner, that would still be facilitating inspection. And unless a data requester asks you, the government, to make them copies, then you can't charge for it. So it will depend on if this person who's asking you for data is asking to inspect, then it's going to be free. If he wants copies, then you can charge him for search and retrieval. And then the transcription time will depend on what it is. If that's what you need to do to make a copy, or if he's asking you to transcribe it, you could charge him for it. So it will depend a little bit on what the data is, how you're maintaining it, and then what that transcript is. We can certainly talk more about that offline. We have another personnel question, which is, what is a finalist for a position? And that is in section 13.43, again, in subdivision 3. It's the last sentence of subdivision 3, which says, for purposes of the subdivision, finalist means an individual who is selected to be interviewed by the appointing authority prior to selection. All right, just scrolling through. We have a few more minutes. If anybody has any additional questions, we can just leave the line open and you can let us know. We will also be posting the PowerPoint on our webinar webpage too after this. So if you're looking for it, it will be there as well.
Just have a follow-up question that asks, when is the law enforcement specific data practices seminar going to be that we mentioned earlier? We haven't scheduled it yet or posted for it yet. So if you are signed up for our Gov deliveries, you'll get a notification, but it'll be sometime this fall. Okay, we've mentioned to a few of you who have submitted questions that will connect offline after our webinar today. We're just about at our time for today, so if we didn't get to your question, we'll follow up with you. Remember that you can go back to the recording if you want to revisit any of the presentation or the Q&A from today. It'll be on our YouTube page. Please provide us with feedback on the survey that will pop up after you exit WebEx. Let us know if there are any other questions or topics that you want us to address in future webinars, and stay tuned for a Gov delivery notice on our next webinar. Thank you.